In this video, we're talking about a hypothetical situation where a person has been stopped and arrested for a DUI and they have refused to complete any of the tests. They refuse to provide a breath sample or a blood sample. What happens next is the officer will go and get a search warrant. Once that warrant is executed, meaning a judge has approved the officer to go back to the person being charged and say, I have a court order from a judge, you have to give me a sample. What does that person do next? The person can go ahead and voluntarily just agree to comply, or the person can still continue to refuse to provide that sample. What happens then? What happens when the officer shows up and says, hey, I have a warrant to get your blood, and the officer or the person being charged says, so what? I don't care. Well, it's not a good situation in most incidents. What happens then is the officer will usually call other officers and forcibly take a sample. They will forcibly withdraw a blood sample from that individual. I have it written here. If somebody refuses and a warrant is obtained and then they refuse again, they will make a forceful withdrawal of a person's blood sample. And I mean that quite literally. They will take a person and strap them down to a chair. They will Velcro them up to a metal chair and then forcibly go in and take a sample from that individual. In certain situations, that person may have basically an anti-spit device. If they're spitting at somebody, they will do anything they can to strap that person down to physically immobilize them while they are taking that sample. So it's generally not a good thing to do. We will recommend that if you have an option to go ahead and give a sample once a warrant has been generated and obtained by the police, because it only gets worse if you refuse it on top of a warrant. The police will charge you with additional crimes. We see this when this happens. The police will go ahead and file additional charges or tack on additional charges to the underlying DUI case. They will add on a failure to comply with a court order. So now they are approaching you and they're saying, I have a court order, a judge granted me the right and the permission to take a blood sample with a valid warrant, and you are refusing to comply with the judge's order to give me that sample. I've seen them charge people with failure to comply with a court order. It's a separate crime. They'll also charge people with failure to obey a police officer. So an officer will then say, pursuant to this valid warrant that I have, I'm asking you to stop resisting, to voluntarily give me your arm, to strap your arm to this chair. Once a person refuses that, if they're jerking back or if they're being combative, the police officers will charge you with an additional failure to obey a police officer. We've also seen certain situations where individuals will become very angry when people are being detained by the police, when we have multiple officers surrounding them. We've seen situations sometimes with 5 or 6 police officers tackling onto somebody. When somebody starts kind of thrashing around, sometimes the police will be injured. So if the police are injured, or if there's bodily fluids being sprayed out of somebody's mouth, or if somebody's kicking and an officer gets bruised or scratched, they can charge you now with an aggravated assault against an officer. It's a felony offense. If an officer is injured, it can elevate it from a lower level felony to a higher level felony. So it's a very serious charge. So you can see how these things can kind of snowball. Once somebody refuses to comply with a warrant, things will snowball and they can start tacking on additional charges. And we've also seen situations where individuals are charged with what's called criminal damage. So if things are getting broken, if there's damage to the chair, if there's damage to desks or surrounding property, wherever this is being done, they can charge that individual with criminal damage as well. So additional charges can be stacked on. It's also not generally advised to do this because it will also result in typically a more painful blood draw. So you can imagine if you're being tackled by a group of officers and they're forcibly withdrawing, it's not going to be as easy as it would be if you just gave them your arm and complied with it. And this also does not look good to a jury. So this is generally something where if a jury sees this happening, unless there's good cause, unless an individual had some mental problems or some incapacity where they were not understanding what was happening, or they were under the influence of something that maybe they were not responsible for ingesting knowingly, then this can be something that is very problematic to put in front of a jury. If the government wants to introduce this, if a DUI case goes to trial, for example, introduce this as evidence, a jury may look at this and say this person was being completely unreasonable, and they may, whether the underlying facts of the DUI are enough to incriminate that individual or not, it doesn't matter. A jury can take a look at this and say the person was behaving improperly, and therefore they're just going to impute liability, impute guilt regardless of what the underlying facts show as it relates to the DUI case. So this is what happens when an individual refuses to comply even after the officer has gotten a warrant. If you find yourself in this situation, just because I kind of painted a dire scenario here, doesn't mean that you have to have no hope in your case. There's a lot that leads up to getting to this point in a DUI case, and there are many things that can happen prior to this actually happening in your case that can invalidate the DUI, or evidence can be suppressed or thrown out. So I don't want you to feel like watching this you have no hope. If you find yourself in this situation, give us a call. We work with people on these types of cases all the time. We have free case evaluations, so we'd ask you to give us a call. Come into our office. We'll sit down with you. We'll talk about the facts of your case, talk about the extenuating circumstances that certainly apply, and we'll make sure that you have a good understanding of how this works, and more importantly, have a plan to work through it. So give us a call. We look forward to speaking with you soon. Thanks for watching.